The British royal family faced an unprecedented crisis in February 2026, one that shook the foundations of the monarchy and left the public riveted to every unfolding detail. Prince Harry, known for his openness in discussing personal matters, revealed painful details about the long-standing rift between him and his family. According to sources close to the palace, Harry insisted that there could be no real peace between him and his relatives until the truth was fully revealed. The tension reached a peak on the morning of February 17th, when Prince William appeared in front of cameras at Buckingham Palace alongside Princess and Anne, the Duchess of Edinburgh. The announcement they made left the world in shock. The marriage agreement between Prince Harry and Meghan Markle, signed on February 15, 2026, was now official. This agreement was not just a private matter. It came with consequences that were both far-reaching and irreversible. For the Crown, the decision reflected centuries-old principles to protect the future of the monarchy while upholding legal and moral obligations. In 7 carefully chosen words, Prince William declared the agreement final, a phrase that compressed over a decade of tension, media scrutiny, legal disputes, and emotional turmoil into a single statement. For those following the monarchy closely, this declaration marked the end of what had been one of the most publicly examined and debated marriages in modern royal history. However, the agreement itself contained far more than a legal conclusion. It held revelations that would ripple through the family, the courts, and the global media. The significance of this agreement became clear when examining the documents behind it, especially a 94-page settlement that detailed every aspect of the divorce and custody arrangements. These documents were not vague or general. They were precise and thorough, reflecting the severity of the situation. To understand why this settlement was so important, one must look back to February 3, 2026, at Windsor Castle. At that time, Princess Anne, known for her methodical approach and strategic thinking, presented what insiders referred to as the moral withdrawal file during an emergency meeting with King Charles and Prince William. The file contained the words, "immediate custodial breach," which sent shockwaves through the palace. The dossier described, in exact detail, how Meghan Markle had allegedly withdrawn her children, Archie, aged 7, and Lilith, aged 5, from their schools in California, without notifying the royal child welfare officers. It also reported that medical appointments were blocked, communication channels were severed, and a significant education trust worth £6.3 million had been dissolved. Princess Anne's assessment emphasized that these actions were not simple oversights or mistakes. They represented a deliberate pattern of disengagement and escalation. This raised an important question. Why would such a high-level legal document exist if this were merely a routine family separation? The answer, the palace concluded, was that the actions represented a threat serious enough to invoke centuries-old legal mechanisms, ones that had not been used for decades. Within 24 hours, the Royal Emergency Guardianship Protocol was activated, a legal tool designed to protect minors in extraordinary circumstances. This protocol had last been invoked during the post-war succession crises of the 1950s, highlighting the severity of the situation. By February 5th, Prince William had escalated the response, invoking a clause of the Royal Succession Stabilization Act, granting the Crown full custodial control over Harry and Meghan's children due to what was described in the documents as an existential threat to their identity. Meghan Markle was reportedly absent from these proceedings, her legal team made no filings, and she remained publicly silent. Her silence, according to palace aides, spoke volumes. The February 15th agreement formalized what had been unfolding behind closed doors, covering 6 main areas: division of assets, custody arrangements granting the Crown permanent guardianship, financial obligations including child support, personal property and premarital assets, residential access rules, and public conduct clauses, including non-disparagement agreements. The documents were groundbreaking, and within them lay clauses that would become the focus of intense public attention, particularly Clause 14C, which regulated the use of the children's likenesses and identities. This clause was designed to prevent exploitation of the children in any commercial, media, or artificial intelligence contexts without explicit permission from the Crown, and it was enforceable worldwide. Meghan's refusal to sign certain aspects of the clause, reportedly because she intended to use Lilith's likeness commercially, created one of the first public flashpoints in the dispute. Equally dramatic was Clause 7, a previously sealed prenuptial agreement drafted in 2018 that granted Meghan sole intellectual property rights over Harry's likeness, voice, and memoir materials, effectively allowing her to control how his narrative appeared in public. The implications of this clause were enormous. Every interview, documentary, memoir passage, or podcast involving Harry could be filtered, edited, and licensed under Meghan's authority. According to insiders, this meant that the public narrative of the Sussexes' life, once perceived as a joint venture, was, in fact, heavily curated and controlled by Meghan. Legal analysts described this as one of the most aggressive narrative control measures ever seen in a marital contract involving public figures. Confidential testimony from palace members suggested that neither Prince Charles nor Queen Camilla were aware of Clause 7 during the wedding proceedings, and had they known, it is unlikely the union would have received ceremonial recognition as it did. Allegations also emerged that Prince Andrew was involved in back-channel communications with Meghan's legal team, providing insights into potential vulnerabilities within royal legal structures, though the investigation was ongoing. Prince William reportedly described the situation as premeditated betrayal, underscoring the depth of the family's shock and dismay at the unfolding events. Financial complications added another layer of drama to the saga. By February 16th, it was revealed that the Montecito property owned by the Sussexes was near foreclosure, following a $9.4 million bridge loan structured through a Delaware holding entity with high interest rates and strict repayment terms. Meghan had allegedly attempted refinancing, but underwriters raised concerns over inconsistencies in the Archewell Foundation's financial records. These financial struggles contrasted sharply with the carefully curated public image of the couple, revealing the complexity and fragility of their financial situation. The combination of legal, familial, and financial pressures created a perfect storm, one that highlighted the extraordinary measures the Crown took to protect both the children and the integrity of the monarchy. The entire series of events represented not just a custody dispute but a constitutional moment that would reshape perceptions of the royal family's authority, the role of public figures in managing personal narratives, and the mechanisms used to protect minor children within high-profile families. The most explosive aspect of the February 15th settlement was undeniably Clause 7, which fundamentally shifted control over Prince Harry's public narrative to Meghan Markle. This clause, sealed in a prenuptial agreement drafted in 2018, granted Meghan sole rights to Harry's likeness, voice, and any unpublished material from their joint life starting in 2016, including his interviews, memoir passages, and media appearances. Experts described it as one of the most aggressive forms of narrative control ever granted in a marital contract for public figures. This meant that every podcast episode, television interview, Netflix special, or public appearance featuring Harry had to pass through Meghan's approval before release. While initially framed as a mutual effort to preserve privacy, the clause effectively gave Meghan unilateral control over the Sussex legacy, a fact that shocked the royal family when the documents were unsealed. Inside sources revealed that the clause was carefully negotiated by a U.S.-based law firm and had been kept confidential from key palace officials, including Prince Charles and Queen Camilla. The public only learned of its existence after fragments were leaked during a confidential inquiry led by the Lord Chancellor's office, sparking global speculation about the balance of power between the couple. Legal analysts emphasize that while marital agreements granting rights to personal intellectual property are not uncommon, the scope of Clause 7 was exceptional because it applied to all media, commercial, and literary uses of Harry's identity, effectively placing him in a position where he could not independently control his story. The ramifications of Clause 7 extended far beyond the couple themselves and into the global media landscape. Previously, the Sussexes' public image had been carefully curated as a joint brand, representing a progressive and inclusive royal couple standing up to media intrusion and modernizing the monarchy. However, the existence of Clause 7 indicated that this narrative may have been more calculated than it appeared. By controlling all media output, Meghan could determine what elements of Harry's life were highlighted, omitted, or reframed, including the couple's decision to step back from royal duties in 2020. Analysts suggested that this level of control over one partner's public persona is unprecedented in modern royal history and posed ethical and legal questions about power dynamics in high-profile marriages. The clause's discovery prompted a reevaluation of how much autonomy Prince Harry truly had over his public narrative and whether the couple's brand strategy had been designed for mutual benefit or was strategically skewed in Meghan's favor. Experts also warned that such unilateral control could impact future historical accounts, biographies, and documentaries, as any content would be subject to approval or denial by a single individual with commercial and personal interests at stake. Complicating matters further were allegations involving Prince Andrew, who was reportedly in contact with Meghan's legal team regarding Clause 7. While Andrew had long been considered persona non grata within the palace, sources claim he provided insight into potential legal weaknesses or vulnerabilities that could affect Harry's control over media content. This alleged back-channel communication was seen as an attempt by Andrew to secure potential future rehabilitation opportunities in exchange for strategic information, though investigations were ongoing and no formal confirmation has been issued by the palace. Regardless of the extent of Andrew's involvement, the mere suggestion of collaboration outside official channels intensified the drama and sense of betrayal within royal circles. Prince William's reaction to the unsealed documents reportedly characterized the situation as not merely a familial dispute but premeditated betrayal, inked in legalese, signaling the depth of the palace's dismay. Queen Camilla's response was reportedly succinct and telling. She wanted the story, not the man, indicating a recognition of the profound narrative implications of Clause 7 and its potential to alter public perception of the Sussexes and the monarchy as a whole. The public implications of Clause 7 were just as significant as the private ones. Social media erupted as news outlets and fans began dissecting the legal language and hypothesizing about the impact on Harry's media engagements. The clause set a precedent for how intellectual property rights and personal narratives could be negotiated in high-profile relationships, drawing attention from legal experts, celebrity attorneys, and child welfare advocates alike. For ordinary viewers, the concept of a spouse controlling every public appearance of their partner may have seemed dramatic or even extreme, but in the context of celebrity marriages, it underscored the intersection of personal relationships, commercial interests, and media control. Commentators noted that the clause created a rare tension. While intended to protect privacy and secure the couple's brand, it also effectively limited Harry's independence in managing his own public story. This dynamic highlighted the delicate balance between safeguarding family reputation and asserting personal autonomy, a tension that resonated not only within the royal family, but across the broader conversation about celebrity, media, and intellectual property rights. At the same time, the settlement included Clause 14C, focused specifically on protecting the children, Archie and Lilith, from exploitation. This clause prevented either parent from using the children's likeness or identity for commercial or media purposes without explicit written clearance from the Crown, enforceable globally. While the clause was designed to safeguard the children, Meghan reportedly refused to sign it fully, citing her plans to use Lilith's image in a proposed children's book series titled Lily and the Lighthouse. This refusal highlighted the tension between personal ambition and the Crown's protective measures. Legal experts emphasized that Clause 14C was not about restricting creativity or entrepreneurship. It was about ensuring the psychological well-being and privacy of minors, particularly in the context of high-profile families. The combination of Clauses 7 and 14C created a scenario in which personal rights, commercial interests, and child protection intersected, leading to unprecedented legal and ethical challenges that captured worldwide attention. Alongside the legal and narrative battles, the Sussexes faced severe financial turmoil that compounded the drama. By mid-February 2026, it became clear that the Montecito estate, one of the couple's most high-profile properties, was on the brink of foreclosure. Behind the scenes, Harry and Meghan had relied on a $9.4 million bridge loan secured in 2025 through a Delaware-based holding entity, with terms that proved extremely punishing. The loan carried interest rates ranging from 14.25% to 25%, a 9-month repayment window, and zero flexibility for missed payments. Unfortunately, the couple failed to meet the January 31st deadline, triggering the first cascade of financial consequences. Reports revealed that Meghan had quietly sought refinancing through a boutique Manhattan lender specializing in distressed celebrity portfolios. However, underwriters raised red flags after reviewing the Archewell Foundation's audited statements, which showed troubling inconsistencies, casting doubt on the couple's ability to meet their financial obligations. While social media and public appearances painted a picture of a prosperous and carefully managed brand empire, the reality behind the scenes was starkly different. Months of polished online narratives and media engagement had obscured financial instability, leaving the monarchy and global observers stunned when the truth emerged. The collapse of Montecito property finances had broader implications than just lost revenue. Legal experts emphasized that such financial mismanagement complicated the ongoing custody and intellectual property disputes, as any shortfall or bankruptcy could affect the children's future. The enforceability of Clauses 7 and 14C, and public perceptions of the Sussex brand. Sources close to the palace reported that financial disclosure documents revealed tangled liabilities involving both U.S. and international entities. Some of these assets had connections to previously defunct Dubai-based media syndicates, adding yet another layer of complexity and intrigue. This tangled financial web not only reinforced the Crown's decision to assume permanent guardianship of the children, but also fueled media narratives about the couple's decision-making, judgment, and priorities. In effect, financial missteps intertwined with legal battles, highlighting the high stakes for all parties and underscoring why the monarchy intervened so decisively. The public reaction was immediate and intense. International news outlets picked up on the story, framing it as both a legal and financial crisis. Headlines emphasized the dramatic elements: high-interest loans, failed refinancing attempts, and looming property foreclosures. Social media amplified speculation, with commentators dissecting every detail, including connections to offshore entities, the Delaware Holding Company, and the supposed links to international syndicates. Analysts suggested that the financial narrative further complicated Harry and Meghan's attempts to control their story through Clause 7. While Meghan had gained authority over Harry's media presence, the couple's financial mismanagement made the public narrative harder to shape. The tension between carefully curated media appearances and the stark financial reality created a powerful contrast, one that legal and financial commentators argued was almost Shakespearean in scale. At the heart of this storm were the children, Archie and Lilith, whose future was tied not only to their parents' relationship but also to the stability of their financial and legal environments. The palace, meanwhile, viewed these financial revelations as additional justification for the intervention. By assuming full legal guardianship over Archie and Lilith, the monarchy sought to safeguard their education, healthcare, and overall welfare. Coupled with Clause 14C, the Crown ensured that the children's images and likenesses could not be exploited for commercial purposes without oversight, even if their parents were unwilling to comply voluntarily. Experts emphasized that this represented a modern approach to child protection within high-profile families, blending centuries-old legal principles with contemporary concerns about media